everybody and welcome to the first ever LAB news feature. This is a new thing that I'm doing whereby I pick out a few of the key legal news stories from the last couple of weeks and tell you about them. So without further ado, let's read some news. First up, gig economy. What is it and why is everyone talking about it? The gig economy is this new kind of employment relationship whereby workers have complete flexibility to sign up for whatever gigs they want, whenever they want, and they only get paid for the gigs that they do. So they don't get a fixed wage, they have no fixed hours, they have complete control over their own working hours. So why has this been in the news? This has been in the news because it challenges a few key areas of employment law and the overlap between different types of employment relationship. Employment law in England recognises three different types of workers. One, employees. So employees are employed under a contract of employment with their employer. Generally, they have fixed and regular hours and a fixed and regular salary. And because of that relationship, they are afforded certain protections by that relationship, including entitlement to sick pay, holiday pay, right to minimum wage. The employer does their taxes for them, and they also have a right to redress against unfair dismissal claims and the like. So that is an employee-employment relationship. The second type is independent contractors. They are the complete opposite end of the scale. So they have no employer-employee relationship with the companies who they are doing jobs for. They are completely self-sufficient, they do all their own taxes, all their own paperwork. They're not entitled to any sick pay or holiday pay or anything from the company who they are doing the job for. They are just purely contracting on an independent basis, hence independent contractors. Then there's a third section, which is kind of a middle ground called workers. So workers have much more flexibility than an employer-employee relationship, but the employer or the company they're doing work for has slightly more control over them than they would do if they were a completely independent contractor. And because of this, they are afforded some of the protections like holiday pay, but they don't get the full package that an employee would do. So where does Uber fit in? Uber fits in because a couple of drivers decided last year that they thought their relationship with Uber was more like a workers' relationship than it was an independent contractor relationship, which is what Uber had always claimed that it was. So when this case was brought, one of the key factors for deciding whether or not they were workers or independent contractors was the amount of control that Uber actually had over their drivers. And it was found that actually because Uber imposed certain controls like a minimum fare that could be charged, and also the fact that the drivers weren't allowed to repeatedly decline jobs. If they did that, then they were shut out of the system for 10 minutes and couldn't log back on. And because of that, Uber was found to have quite a lot of control over their drivers, and Uber actually won the right to be considered workers rather than independent contractors this year. Contrast that with Deliveroo, who essentially made the same point, but when the court looked into the case of the delivery workers, it was found that Deliveroo workers were far more independent than Uber drivers were from Uber. So delivery drivers essentially could pick up and drop off whenever they wanted, and crucially they could substitute someone else to do that drop for them if they couldn't do it at the last minute. And that issue of substitution really made a massive difference to their case from Uber's, and it was ruled that Deliveroo drivers were independent contractors and they were not workers. So that is the current position. That is the difference between your cab driver and your delivery boy, if you're interested. Next up, Leigh. Oh gosh, Leigh have had a really tough run recently, and if you haven't heard anything about Leigh in the last couple of years, then you have been living down a well. But here is the latest from Leigh. In 2004, big fight broke out in Iraq. A bunch of Iraqi militia ambushed UK military patrol, and as a result of that, the UK military patrol was said to capture some civilian Iraqis and torture and mistreat them. Leigh took on the cases of those civilian Iraqis, and what transpired was that those cases were entirely fictitious, and the Iraqi civilians were in fact part of the Iraqi militia rather than innocent civilians. Every claimant lawyer's worst nightmare. Your client's completely lied to you and now you're stuck up the creek without a paddle. However, what was important in this case is there was actually a document called the OMS list, which Leigh had in their possession, which confirmed the identity of their clients and their status as Iraqi militia. However, Leigh, for whatever reason, overlooked this document, didn't realise its significance, and didn't disclose it to other solicitors involved in the litigation and the court. At that point, the SRA got involved and said, this sounds like misconduct, we're going to bring a claim against Leigh for acting without integrity. So the hearing went ahead in June of this year. All solicitors cleared of any misconduct. Hooray for Leigh. However, what's not so bueno is the £7.5 million bill for legal costs that Leigh spent defending themselves against these allegations. So naturally they want some of that back from the SRA because they were successful, and that is the present position. However, what the SRA have said is that they're going to appeal the decision that the Solicitors Disciplinary Tribunal made, and they potentially have quite good grounds for appeal. One, because 1 out of the 3 disciplinary judges dissented, so it wasn't a unanimous decision. And 2, it was an issue that was very much in the public interest because of the issues that were in dispute and the circumstances that gave rise to the claim. So we'll see what happens with that. Potentially it will be appealed, and I will keep you updated with what happens with that in the future. So last but not least, something a little bit more light-hearted. This Birmingham student who got a VK bottle tattooed on his thigh. If you are this man, I would strongly suggest you never reveal yourself or your identity, because although each to their own, if you love VK that much, you go ahead. It will not win you any brownie points in your training contract interview or in the office once you're employed. So with that thought, I'm going to leave you considering all of your life choices and how they may affect you in the future. All of today's stories will be linked in the description, and also more likely than not they will be tweeted or retweeted on my Twitter page. Please follow me here. And I hope you've enjoyed this. Let me know what you think and if you want me to do more of these features. Until next time, LAB out.